Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about divorce and family law with an emphasis on orders of protection and domestic violence. Joining me once again is my co-host Jesse Barrientos. Jesse, welcome, sir.
Great, Dave. Thank you very much.
How are you today?
Excellent. How about yourself?
Okay. Well,
it's a happy day.
This is an apropos topic because you happen to be in court today on a divorce or a post-decree divorce with a order of protection involved in it. So let's jump in. Oftentimes we have a divorce case that leads to either domestic violence or orders of protection mixed within there. How do you handle those type of cases? The same way as an underlying divorce, or is it a little bit different?
It's a little bit different. I mean, sometimes what happens is, and there are various combinations, but a lot of times what happens is an order of protection or a domestic violence charge is a prelude to the divorce. Some people try and they think that they can gain an advantage in the divorce by having, for example, in one of the remedies in an order of protection is to get exclusive possession of the residence. And of course, you have an exclusive possession and you have the kids and you have physical possession of the kids until an actual hearing that involves the other side is had on that, I mean, is really a huge advantage. Also, obviously, if there is a domestic battery, which is now criminal, we're blurring the lines. I think we need people to know that an order of protection is civil in nature. Domestic battery is just like a battery. I mean, that's criminal in nature, and very often they go hand in hand. You could have a domestic battery without an order of protection. You can have an order of protection without a domestic battery, or you can have them both together. It just depends on the specific circumstances, but very often it's a prelude for that.
Okay, and can you have an order of protection initiated first and then file a petition for dissolution within that existing case, or are those separate?
That'd be separate. If you filed an order of protection independently of anything else, and there's no divorce or anything else going on, it would have its own separate number. Very often, I mean, you have the year, which is 2011, OP, and then whatever the number, how many have been filed, dependent upon which county you're at or anything like that. And so that's what will initiate that. Now, depending upon which county you're at, now again, generally, and I say generally because it's not always true, but when something like that's happened, I mean, the marriage is done, and they need to move on. Counseling, reconciliation's not an option. They may have already tried it, or basically in their minds, it's dead. And so a lot of times what'll happen, even before we have the hearing, what'll happen is when somebody does an emergency order of protection, they'll go in, it's a verified petition, they can do it on their own, it's called pro se, and they will fill out a form that alleges the specific allegations of exactly what the other person is alleged to have done. Now,
when should somebody seek that? When is it warranted? When it's beyond just an argument, when does it accelerate to the point where you think an order of protection would be recommended to a client?
Well, I think order of protections are overused. I think there's a huge, tremendous abuse in those proceedings, because I think a lot of the judges, what they'll do is they're going to err on the side of the children. And I understand that. I mean, nobody wants to make a mistake where, okay, well, they should have done this, they did something else, and as a result now a child or somebody else is physically or even mentally injured for that matter. So I do understand that, but it's a process that is just abused all of the time. I would say that if you're in a situation, for example, where the other spouse, or it doesn't even have to be a spouse, it could be a situation where the parties aren't even married, which would involve family or paternity court. A situation like that, I mean, it doesn't even have to be a situation where there is a divorce pending. It could be where you're living maybe with a dependent minor or with an old elderly person. I mean, there are various scenarios that you can go through with that. But if somebody has, and we'll take it in the divorce context is that we're talking about, if somebody says, hey, listen, you know what, I'm going to take the kids, I've got tickets to go to Mexico or to go to Canada, and I'm taking the kids, and the heck with you. All right, well, you know what, and you believe that's what's going to happen? Hey, guess what? That's what you need to do. Now, is that paper going to stop the person from realistically, getting on the plane, getting a ticket, and all this other stuff? No more than it's going to stop somebody from hitting you if you're waving it before, hey, you can't touch me, I got an order of protection. All it really does is increase the severity of the sentence.
Yeah, plus should it be violated, you can bring that person back into court, and that does increase the penalty phase, so to speak.
Exactly right. But I mean, there are many. I tell people all the time. They ask me, and sure, you can go and get an order of protection with your attorney and all that. But very often, it's on an emergency basis, and if we're available, great. We're able to go there and do that for you. But hey, if you need to get in right now, you can do that on your own. But again, you have to, the allegations, I mean, it has to be something that's an emergency. A lot of times people think that emergencies are emergencies that really aren't emergencies, if that makes any sense at all.
Not in the court's eyes.
Right. All right.
Let me ask you this. If someone goes in for an emergency order of protection, you said they can do it ex parte, pro se.
By themselves,
they're
sure.
just in front of the judge. They're going to routinely get that granted if they can make some kind of showing of endangerment or intimidation, harassment, that kind of thing, correct?
Harassment or abuse. And by the way, so the folks at home know, ex parte means it's a hearing had just with one party. That means that basically I'm going to the judge and I'm saying, hey, listen, these are the allegations. This is the reason why I need to have this order entered before I can even give notice to this other person. Because if I give him notice, then he's going to do the very thing that I'm telling you, Judge, that he's going to do or that she's going to do. And, I mean, it's having a one-sided argument. It's being unrepresented. But it's only good for 21 days. And then
that's a lot, though, if it's putting somebody out of their house. It's a
lot. Absolutely,
and separating them from their children and their belongings. 21 days is a long time to go find alternate housing.
Sure.
Alternate
to get your
clothing.
Stuff. Well, imagine your stuff. I mean, what are you gonna wear? Of course, you have to be served with order protection. But what are you gonna do? You're ousted from. Now, imagine anybody at home. Think of it right now. Right now, maybe you're sitting in a restaurant. You're having a nice meal. You're having maybe a glass of wine or club soda or whatever. And all of a sudden, now, boom, you can't go back to your house. Well, gee, today is Tuesday. At least right now, as we sit here today, I would suspect that you have to go to work tomorrow. I would suspect that, I don't know, maybe your laptop is at home. Maybe you have some files that you brought home to work on. If you did, God bless you all. But, how are you going to be able to get that? It's going to rock your world to the foundations.
But hopefully that person has their cell phone and they're going to get in contact with someone like you, a competent attorney who can go in and quickly try and get that vacated to either get them back in the house or get them their belongings pending the actual full hearing, correct?
That's correct. You could go in with 2 days notice, personal notice, to be able to have that hearing, either to have the full-blown hearing, to have it vacated, or to ask that you are able to get some of your stuff.
With an escort.
With an escort, generally, that happens. Or even to get some visitation, because a lot of times orders of protections are entered. It's not that there's necessarily a concern with the minor children. It's that there's a concern with the other spouse, but then there's no problem with the child. I mean, again, depending upon the circumstances, these things can play out in various different ways.
What percentage of orders of protection don't go through? In other words, they get the
first time?
They get the emergency order, but then when it comes up for that hearing 21 days later, what percentage of those are either dropped or the party doesn't show up and it's not turned into a 2-year extension?
Well, it's difficult to really put your finger on that because, again, things are different. Again, judges are really wanting to err on the side of caution. But I don't necessarily think, I don't know what the specific statistics are on that. But
if you had a guess, what would you say, 20, 30%?
I don't think all of them are, and for this reason, there are a lot of attorneys out there that, and again, remember I said that it's a prelude a lot of times for a divorce, for domestic relations action. And a lot of times what will happen is before we even go in to have that hearing, we'll have the domestic relations, the dissolution case filed. And what happens is most of the counties have a local rule which says that if there's an order of protection, that it will go to the divorce judge, exception that I could think of here, sitting here, I believe is DuPage, where you're going to have the hearing on the order of protection with the order of protection judge, and then it will be transferred to the divorce or to the paternity judge or whoever that may be. But most of the other places is they're not even going to hear it. It's going to go directly to that person, and that's an advantage only because here's the person that's going to hear everything from here on out, right, and you want him to listen to everything. But I said all this to say that what happens a lot of times is what we'll do is a temporary or a mutual restraining order, which basically restrains you from interfering with my personal liberty, with harassing me, with doing all those kinds of things, and vice versa. And it's not in the guise of an order of protection. Order of protection, if officer pulls you over, if the employer looks, they'll be able to find that. That might hamper your your job requirements depending upon what you do. The benefits of an order of protection are that they are certainly able to be enforced by law enforcement, as opposed to a temporary restraining order, which is going to require you to come back into the divorce court and to ask the judge to enforce what the particular terms are.
Right. I must tell you, Jesse, a lot of people out there, attorneys and laymen, often think that an order of protection is not even worth the paper that it's written on, because it's not going to prevent that person from taking an action just because there's an order on a piece of paper. But I wanted to bring up this point, and I've seen this many times. The person who actually gets the emergency order of protection winds up making contact, either by phone or email or in person, with the very person that they just sought the order of protection against. So it's almost like it starts something, but it doesn't often escalate. It often is a tool, an argumentative thing. I got an order of protection against him, or vice versa.
Sure.
And it kind of gets resolved before a full hearing, often.
A lot of times that does happen, and I have to tell you, and for all you people out there, if somebody has an order of protection against you and they make contact with you, run in the other direction, because guess what? It's still a violation of the order of protection, even if they went and contacted you and you are in peril of jail time. I'm telling you that.
Right.
Run in the other direction. Seek legal counsel.
But you can use that at the plenary hearing.
Sure you can.
As evidence that obviously this person was not intimidated by me. They left me 10 voicemails and 6 emails.
But it's a technical violation. If
Correct.
I'm not supposed to contact you, and not supposed to do any of those kinds of things, and I've indulged you, hey, and you're right. A lot of times, what it is okay. Hey, you know what, Dave? And now we have, I guess, the civil union laws, so that's applicable to same-sex couples as well. Hey, you know what? I'm going to show you your place. I'm going to show you that you can't mess with me. I'm going to show you that you have to respect me, because I'm going to get that order of protection. You're going to be out of the house, and you're going to pay my way.
Yeah.
How about that?
How is the person who has the order against them served after the initial emergency order is
Personally.
entered? By the sheriff?
By the sheriff.
How many days after it's entered?
Well, as soon as they can find you. There's been a lot of situations. Now, they have to have the hearing, according to the statute, within 21 days from the time that the order of protection is entered. However, if they can't find the other person in order to effect service, then they can extend it for a like period of time in order to do that. Now, they'll allow that to happen a few times, and after that, it may just really get dissolved. But let's look at another aspect of the order of protection where there is a domestic battery involved.
Okay.
And what'll happen is, definition of a battery, from law school is what?
The unlawful touching.
Right. Intentional, unpermitted, harmful, or offensive touching. That, folks, is the definition of
which most people think is a punch, but
Right.
in reality, it could be a slap,
Right.
it could be a spit.
It could be anything.
A push.
Intentional, harmful, or offensive touching. Well, intentional, that means I have to intend it. That means that if I get into a car accident with you and I hit your car, okay, that's not really intentional, unless and I've had cases where somebody really tried to hit
Right.
the other person. But, that wasn't intentional. That's negligence, a whole nother show. But intentional, okay. Harmful or offensive. Okay, what's harmful? I popped you in the nose and broke your nose. Okay, well, I'd say that's kind of harmful, right? Or offensive. What's an offensive touching? I spit in your face. Or,
inappropriate touching
inappropriate
in a sexual
touching.
nature.
That's true. Could grab somebody on the rear end, on their and their chest. Could also even applies to maybe let's take a purse, which is different. That would still be a battery, not necessarily a domestic. Domestic battery refers to someone in the same household, generally a spouse or anybody who's in the household,
And not necessarily of opposite sex.
not necessarily opposite sex. That would make it a domestic battery. But a regular battery, very similar, is let's say a purse snatching. Somebody snatches somebody's purse, they yank the strap or the purse off of them, and that's a both kind of a harmful and an offensive touching, really,
Yeah.
right? To be able to do that. The issue with those things is that now you have a criminal case. And the difference really between a domestic battery and a regular battery is the sentence.
Now it's a Class A misdemeanor, correct?
Well, they're both Class A misdemeanors. The difference, though, is the sentence. For a regular battery, you can get what they call supervision. Supervision is not a conviction. What it allows to happen is if you fulfill the terms of the court sentence for whatever it is, 3 months, 6 months, 12 months, maybe some anger management classes, pay a fine, whatever. As long as you do that, then your case technically will be terminated and discharged, and it's not a conviction. Conviction will not enter.
Much like supervision for a traffic violation.
Right, exactly right. That doesn't get reported to the Secretary of State or anything like that. With respect to a domestic battery, you don't have that option. The judge, the legislature has taken it out of the judge's lap. He doesn't even have the authority to be able to enter that sentence, to order that. So it's
what
going
are
to be
the
a
options?
conviction.
Or conditional judgment, correct?
Or it could be a conditional discharge, which is a conviction. It could be probation, or and certainly just a straight-out conviction with time, depending. If I really battered the heck out of you and maybe really did bust your nose. I mean, depending. Maybe I hit you in the face with a tire iron. I mean, I don't know. I can imagine some pregnant women in the midst of their pregnancy, not getting the response they need from their husbands. And I mean, hey, I don't know. We just had that here in the studio not too long ago, didn't we, Dave?
Yes, right.
Yes.
Now, can the charges be dropped down from domestic battery down to a regular battery?
They can be amended, and a lot of times, depending upon which county you're at, that's a way to be able, because most of the cases are plea bargains. They don't go to trial, and that's a really efficient way of getting rid of things. Because if they're able to do that, and so instead of a domestic battery to reduce the charges, or not really even reduce, to just amend the charges to a regular battery, then that's something you get supervision on. The other thing too is a battery is something that you can get expunged off of your record after a couple years from the date of the discharge of your sentence, whereas a domestic battery going to be on your record.
Okay. What if the plaintiff decides not to prosecute the case? Can the state's attorney compel that person to testify against the person that they originally sought the order against?
He can, and as a matter of fact, and I'm going to say it, there was a case in Joliet where that exact same thing happened.
Will County.
In Will County. And the judge held that person, the paper said, oh, a victim of domestic violence gets arrested now. You have to understand, it's a different kind of a vehicle because it's what you call contempt. If you don't comply with the subpoena, if I rightly serve you with a subpoena to appear and you were served with it and you had notice and you don't show up and there's no justification, like you're not in the hospital, you're not dead, you're not injured, they can hold you in contempt. And one of the punishments for contempt is incarceration.
My question, though, is why wouldn't they let this plaintiff drop the charges and not testify? What's the state's interest in compelling this person to testify?
This is the question. I'll tell you, a lot of people think that the victim is represented by the state. Not true. That's just the complainant. That's just the complaining witness. That's just the complaining victim. The state represents the interests of the state, and it's a breach of the peace of the state. And we need to make sure, Dave, that everybody out there understands that we're going to take care of these things seriously and with prejudice. And what that means is we're not going to tolerate, even though you might not want to prosecute it, it's not your call because we don't represent you and I don't have to listen to you. It's a breach against the peace of the state, and we can strive to enforce it any way legally that we can.
It sounds like a governmental overreach to me.
Well, it may or may not be. Now, is there somebody that was injured in it? Did you bring the charges? Somebody sure did bring the charges. What happens when you bring the charges? Okay, what do you engage? You engage the wonderful wheels of justice, Dave, and what happens about that is that, hey, listen, people have to be paid. Time has to be taken up. There's time on the docket. There's time that goes away. There's resources involved in everything else. Why? Because you wanted to make a point with your spouse. Do you think that's appropriate and you think that's fair?
No, but are you saying because it's a monetary
And I'm
thing,
not running.
I'm
I'm not running for office, Dave. Let me make that clear.
We need to lock him up because we've spent expended money and time on this case.
No. what needs to happen is that justice needs to be dispensed. And a lot of times what will happen is, hey, somebody doesn't show up, the case gets dismissed. But the point of this whole story is that it doesn't have to be that way.
Yeah, but this is real life, Jesse. This isn't a Marvel comic
Well, no.
book where justice is going to be served. This is real life.
It is real life.
That person might have been wrongfully accused,
But
and charges need to be dropped.
and you don't know because there was no hearing because nobody showed up. But I mean, that can certainly happen, and generally that's what will happen. If nobody shows up, case will be, will be dismissed. Now, the case I was referring to, I don't know the specifics. Who knows? I mean, there could have been a very good reason. I'm sure there was a good reason for that. But as the case may be, it doesn't have to get dismissed. It can certainly be possibly continued, although the court might not allow a continuance if the complaining witness is not there.
Let's talk about some improvements to the system. What would you envision seeing happening with regard to orders of protection and how they're handled in the courts?
I wish everyone could just get along, Dave.
Well,
What would
Rodney King and you, huh?
I mean, why can't we all just get along?
Would you like to see a full hearing right from the outset,
Well,
where that person is picked up and
here's the
no ex
problem.
parte?
Here's the problem, and we do this all the time in what we call temporary restraining orders because it's an emergency and we don't have the time to give the other person notice. A good example of that would be you split, you took the $175,000 that you had in the mutual fund and you disappeared it. Okay, that's money that was acquired during the course of the marriage, and hey, we want to stop you from dissipating that money, from wasting away that money. So we go in there immediately, because if I gave you notice of it, between the time that you got notice and the time of the hearing, you could easily say, hey, I got a gambling habit, I was at the boat and whatever. So, there are really legitimate reasons to have ex parte orders entered,
Sure.
in not only for temporary restraining order, but also for orders of protection. I guess there's no real perfect way to do things, but
What about speeding up the hearing time?
well,
Like 21 days.
21 days isn't a lot, but that's what the statute has.
Why not
A
7?
vehicle.
Why not 5?
Well, the statute has a vehicle to allow somebody to come in within 2 days actual, personal notice. And
Yeah,
you're
but not
saying,
everybody can afford counsel.
well, that's
to do
true.
that.
That's true. And when you say, okay, well, they come in with 2 days or 5 days notice, not a lot happens in 2 days, Dave. Not a lot happens in 5 days. Not a lot happens in 14 days, to tell you the truth.
Sometimes the war's over, though, especially if it was not a
Well,
legitimate OP.
But a lot of times those things just don't happen, and so it's kind of allowing enough time to facilitate.
How about a penalty for false allegations? Would you agree to that?
Absolutely.
Hammer that petitioner who makes a false claim.
I think
Lock him or her up for
Well,
a weekend.
we have perjury, and again,
Yeah, but how is it really enforced, though? Come on,
I don't think it really is.
know it's
Well, we don't. No, we're going to enter it. We're going to deny it. And I think if there's no good basis, there should be a penalty. Because I can tell you what, everywhere here, as far as I know, in this free United States, actually in Illinois, there's no charge for a respondent to enter his appearance in a domestic violence, or rather in an order of protection case, except in Cook County, which is, and I'm sorry, you know what? It's just not right. That's not what the statute says. It's appalling to me that should be. But where every place else is no charge to do that because of the nature of the charge itself. And one day I may decide that I have enough time, and I may challenge that.
Okay. Not a bad idea. So that's one change, the monetary aspect of it.
Well, I mean, it should be certainly clear. Nobody else charges for it, and so it shouldn't be, because here, especially if I'm wrongly accused, I don't have the couple $100 to file my appearance. A lot of people don't have that.
Well, as long as you're on that topic, maybe there should be a state mandate with regard to the parenting class requirement and make it uniform and have one place where people can take it, either online or in person, as opposed to every county having a different price, a different length of the class, a different method of taking it. It's chaos.
It should definitely be stratified. And just for the folks at home, whenever you get a dissolution of marriage action filed and there are minor children involved, then what's required really is that both parents have to take a parenting class. And you know what? Hey, it can't be bad. More education on how to deal with children is a good thing, especially when children are in the unique situation where their parents are divorcing. So, it's nice for them to know about that. But I think I agree that, there should certainly be kind of a stratification of, what the course requirements are, where they can take it, and everything else. I mean, that's not a bad idea at all.
Yeah. In the few minutes we have left, Jesse, let's talk about some of the end results from these order of protection. Let's talk about the different kind of orders that the judge will finally enter. You mentioned a stay-away order or a mutual restraining order.
Right, that's different. That's when you get rid of the order of protection if you have a domestic relation case, a divorce case going on too. And so a lot of times we get rid of that and we enter in the divorce case a mutual restraining order.
Okay. What other orders can they enter?
Well, the order of protection can be entered, and it can just be against the spouse. It can be against the, with
For how
respect
long?
to protecting the kids, up to 2 years. And then what
2
happens
years.
is, right, plenary order of protection.
Okay.
There is an emergency order of protection, an interim order of protection, and then the plenary, which can be up to that amount of time. And then what will happen is, at the end of that time, there's a hearing date, and the parties come in, and as long as nothing has really happened between then, between the last time it was entered and now, probably won't be entered, won't be extended, because they can extend it again, right? And but my feeling is it really bothers me. I know that the judges are trying to err on the side of the kids and everything else, but please,
Well, they don't want to make the headlines.
please follow the law. If they haven't proved their burden, if they haven't proved the elements that are outlined and required in the statute, don't enter it. I mean, how much more simple can that be?
What is their burden? Is it a preponderance?
It's a preponderance.
That's just tipping the scale slightly.
That it's more often than not, but that it's more probable than not. But they also have to show that it's, for example, for harassment, that it is an action that is not reasonable under the circumstances and would offend a reasonable person, and they have to have emotional distress, and they have to testify about it. And I've had cases where people pro se, meaning they're representing themselves, haven't said that they experienced an emotional distress, and it was still granted. And for me, hey, I'm a lawyer. I follow what the rules are, and I get it. But you know what, judges, if that's what the statute says, then that's what the statute says. How about following what the statute says?
I told you the judges don't want to make the headlines that say so-and-so judge failed to enter an order of protection, and then look what happened.
Right, but
next.
they failed to order the of the order of protection. They didn't fail to order it. They didn't order it because the burden was not met. There's a big difference, because you know what? That cuts both ways, and that's harsh both ways, and that's harsh on the other side. And you know what? It is what it is, and we'll continue to do what we do in terms of defending people, but it would be nice if they would follow the statute.
How about court-ordered mediation prior to an order of protection hearing, to see if it can be resolved without court intervention, per se?
That also is going to involve more money that I think the courts don't have, or that the parties don't have, because we have mediation.
Well, no, we use the same mediation that's available in Cook County for free.
Well, in Cook County it's free, Dave, but not in the rest of the counties. It's not free.
Well, maybe that's what that appearance fee went towards, because mediation's free in Cook County.
I don't know. It'd be interesting to know what it went toward. But, the judges are doing a good job. The thing is, hey, listen, we need to look at this, and we need to not make it a routine kind of an action.
Yeah. Well, I'm all for things getting better. I'm all for people keeping their hands off one another. But when someone is seriously in danger, it's great that they can avail themselves of the court process and get an emergency order of protection, have the other person served within a reasonable amount of time.
Absolutely.
Set over for a hearing 21 days later, and possibly extend that order for another 2 years to get some level of protection.
If they need it. There are definitely cases that do merit it and do require it. But again, remember that that piece of paper is not going to prevent someone from kicking your door in.
Okay. Thanks, Jesse.
You bet,
Thanks
Dave.
for joining me today. And if you have questions, you can get us at LegalActionTV.com or questions at LegalActionTV.com. You've learned about divorce and family law with an emphasis on orders of protection and domestic violence. We'll see you next time on Legal Action. Take care.